Good afternoon. My name is Antonio Williams and I've been asked to evaluate your terms and use and perhaps overhaul the website's user agreement. I will be discussing major points of emphasis to help navigate this evaluation as well. The first area I'd like to talk about is whether or not your current terms of use is a valid contract. The short answer to the question, in my opinion, is no. Whereas courts have been willing to give click wraps their blessing, attempts to legally bind users with browse wraps agreements have been more controversial. Click wrap agreements, browse wraps do not require a user to engage in informative conduct like clicking on a box in order to show that they agree to a set of terms. Instead, websites with browse wrap agreements often purport to bind their users by passive conduct unrelated to the terms of conditions itself, like continuing to use the website or proceeding past its home page. The use of browse wraps agreements is unfair to users who generally are surprised by these contracts that were never brought to their attention. Accordingly, courts increasingly judge it to be unfair to hold website users accountable for terms and conditions of which reasonable internet users would not be aware just by using the site. Moving forward, to make sure Priceline has a valid and binding contract, they need to make sure users agree to the terms of use before entering the site or before purchasing anything from the site. In a recent case of Schnobel vs. Trilligent Corp, the Second Circuit Court of Appeals provides some important guidance that can readily apply to enforceability of website terms of use and other online agreements. On appeal, the Second Court stated that the inquiry notice requirements could be fulfilled by factors such as copiousness of the terms or the course of dealing of the parties. For example, courts have deemed the inquiry notice requirements to be satisfied by shrink-wrap software license agreements that can only be read and accepted by a license after breaking the plastic wrap around the product package. Since the license cannot commence use of the product without being confronted by the copious terms, and 2, reasonable licenses recognize that they do not return the product, they will be legally bound by the license terms. Similarly, in a prior case, inquiry notice was established for certain terms where a party was repeatedly exposed to the terms following a daily download of data, thereby establishing a course of dealing. The key is that there must be actual notice of the terms or sufficient facts or circumstances to cause a reasonable person to make further inquiries. In this case, however, the Second Court deemed that the inquiry notice requirement was not fulfilled because, unlike the situation with shrink-wrap agreements, the Schnobels had no reasonable expectation of receiving after agreement terms via email. The email terms were not sufficiently copious since they were separated in time and space from the parties' prior contract formation. And the Schnobels could commence using the service without being confronted by or having acknowledged or existence of the emails, unlike the court's dealings case. The Schnobels were not repeatedly provided with the terms as part of their ongoing subscription relationship with Trilligent. In the next point of emphasis, we will discuss whether or not Priceline can be sued. According to the current terms of use, I would have to say yes to that claim. The terms of use states Priceline is committed to customer satisfaction. If you have a problem or dispute, you will have to try to resolve it. If we are unsuccessful, we may pursue your claim as explained in this section. You agree to give us an opportunity to resolve any problem, dispute, or claim relating to any way to the sites and or any of its relevant or related applications or services. Any dealings with Priceline, including with our marketing and customer service agents, the purchase, use, or performance of any services or products available through this site. Any representations made by Priceline or our privacy policy by providing notice to customer support. Unless prohibited by applicable law, any claim must be brought within 2 years from the date on which such claim arose or accrued. If we are unable to resolve your claims within 60 days, we may seek relief through arbitration or small claims court, as set forth below. This agreement shall be governed by the laws of the state of Connecticut, United States of America, without regard to conflict of laws. All claims or other matters in dispute between you and any third party in Priceline, its subsidiaries or affiliates, or any travel service providers or companies offering products and services through the site, whether based upon contract, tort, statute, or otherwise, shall be governed by the laws of the state of Connecticut without regard to conflict of laws provisions that would result in the application of the laws or any other jurisdiction. Overall, not many changes need to be made to the current terms of use. Given the range of options and online services available today, it is now more important than ever that users are actually aware of the strings that come attached to each. At the same time, everyone knows that the majority of users do not and never will read the legalese that pops up on websites. So a forthright presentation of terms to the user at sign up is not enough. Rather, a terms of use should also be publicly available online so that the press, user groups, and consumer watchdogs can examine the agreements and warn and be warned of terms that stray beyond the reasonable or industry norm. I hope that this evaluation will continue to help drive the business in a positive direction and help mold and shape the terms of use in the future. Thank you so much.